Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. I am Michelle Itkowitz, and today we are discussing whether your landlord can charge you for providing you with a replacement key or an extra key. As always, first let us set the stage with some context. You often hear stories of landlords charging tenants in New York City exorbitant fees, sometimes upwards of $200, to make copies of keys to apartments. Also, in the last couple of decades, there have been a lot of changing over in buildings from regular old key systems to non-duplicable keys, electronic key fobs, and key cards. I just had a lease come across my desk the other day for an apartment where this was the section in the lease called additional rent. It goes like this: Keyfobs and Locks. Tenant acknowledges that each tenant has or will receive one access entry device, either a key fob, a key card, or an access code for their smartphone under owner's sole discretion, and one mailbox key for each individual signing this lease as a tenant. Tenant understands that these are the only access entry devices that will be provided during the term of the lease without charge. In the event that tenant loses their physical access entry device or is locked out of the apartment and requests that the owner, its employees, or agents or building staff unlock the apartment, owner shall be entitled to the charges set forth in the lease rider. And then in the lease rider, under the heading Fees, the lease goes on to state, tenant agrees to the following fees from owner. Lost or unreturned key fob or key card, $100. Opening apartment entry door for locked out tenant, $75. Fees are subject to reasonable increases by owner. Now, here is another lease provision in a completely different lease, residential lease. Here's what this one has to say on the subject. Keys/security. Tenant shall not remove, alter, or change in any way the existing locks, security codes, or keys or key cards that are provided for the apartment or any part thereof. Tenant shall not transfer to or share with any person a key or a key card for the apartment. Tenant agrees and understands that tenant will be charged a re-keying fee in the sum of $50 each time a key or key card replacement is deemed necessary by landlord. Said charges shall be deemed additional rent. Okay, so our question for today is any of this legal? We get to the substance of that topic after a short break. Okay, so we're trying to answer the question, can your landlord charge you for providing you with a replacement key or an extra key? So let's get into the substance here. The first law that we are looking at applies to all tenants everywhere in New York State, because this is found in the real property law. And as always, I'm going to put a link to this law in the show notes. This is a fairly new statute. We just got this in 2021. Real Property Law Section 235I. Unreasonable tenant fees for reproductions of keys. And this is what it says. I'm sorry, I have to do a little bit of reading. I'll try to be as animated as possible. As I always tell you guys, the law is words. And here we go. Real Property Law 235I. A landlord shall not charge a tenant a fee for the reproduction of keys to a single dwelling greater than 100% of the actual cost of reproduction, provided such limitation shall not apply if tenant requires the reproduction of keys for a single dwelling more than 3 times in a calendar year. Okay, so put another way, the landlord can't make a profit on charging you for a key, and you can have up to 4 keys because you have your original key and they can't charge you more than they can only charge you at cost for up to 3 times in a calendar year. Okay, so that's the overarching rule for all tenants. However, for our 1.1 million rent stabilized friends out there, there is, as usual, a little bit better rule for the rent stabilized tenants. As usual, they have more protections. So now I'm pulling this rule from a case called Various Tenants of 140-50 Ash Avenue. Now, that case cites this principle, and that principle is backed up by another case cited within the decision, and that case, I checked, was upheld on appeal by the Appellate Division, 2nd Department in August 2024 in a case called 8805-171 LLC versus DHCR. I'll put a link to that in the show notes. So this is what the DHCR has to say about charging tenants for replacements of keys. Okay, here we go. The commissioner notes that the agency's long-standing policy provides that tenants and lawful occupants are to receive free non-duplicable keys, electronic key fobs, key cards. Occupants of the apartment include children who are to be issued non-duplicable keys, key fobs, or key cards if their parent guardian requests it. Tenants may also receive up to 4 additional non-duplicable keys, key fobs, or key cards at no additional charge for employees who may be contractors, professional caregivers, and or guests, including family members and friends who are expected to visit on a regular basis or visit as needed to care for a tenant or the apartment if the tenant is away. Individuals obtaining a non-duplicable key, key fob, or key card must provide appropriate proof of identity, but the owner may not record any data like the driver's license number. Okay, so again, this is quoting from a DHCR decision, and this is the policy. So everybody in the tenant's family gets a free key or the equivalent of a key, an electronic key fob or a key card, whatever it is. And that includes the children if the parents want that. And then also they can get up to 4 additional keys at no extra charge for whoever's coming in. Babysitters, caregivers for elderly people, family members that visit regularly, housekeepers, whatever it is. So those are our rules. So as always, the rent stabilized tenants have a little bit better rule. So this brings up some very important tenant takeaways, but first let's get through that housekeeping. This is not legal advice. I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If this is legal advertising, it's just terrible because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about, and please subscribe, give us the highest rating, and spread the word about this podcast on your socials. It's time for the tenant takeaway. Tenant takeaway time. In the first segment, we looked at 2 clauses from 2 actual residential leases that had come across my desk. And if you recall, Both of those clauses are technically illegal based on the law that we covered in the second segment. Let me tell you how I chose to look at those two particular leases. Again, remember, I don't draft leases. I'm not a transactional lawyer. I'm a litigator. I'm the one who fights in court over the lease when there's a dispute. So, what I did was I took the last three residential cases I worked on, none of which had anything to do with replacing keys, by the way, and I just looked at those three leases. One didn't say anything about extra fees for replacing a key, but the other two did say something, and that's what I read to you, and those clauses did not reflect what the law permits. So the question is, why would that be? Why would 2 out of 3 randomly chosen residential leases have illegal clauses about fees for duplicating keys? Here's the thing. Most landlords are good people, and they provide the housing that we so desperately need in New York City, and that's not easy. But of course, some landlords, not many, but enough, are evil. Ironically, in my opinion, after 30 years of doing this, most tenants' problems arise not because of the evil landlords who eventually the law catches up with. Most problems come because of the ignorant landlords. So very many landlords simply do not know the rules. I see a lot of very naive investors who actually think that New York City multifamily real estate is a passive investment. Nothing could be further from the truth. Running a multifamily building in New York City requires an incredible amount of time, work, overhead, and expertise. There are a million things to know. And the people who are not professional about running their real estate management are also the people who cut and paste their leases together from stuff they found on the internet. And that's how you get a lease where half of everything in there is illegal. Now, don't get me wrong. If you lose your key fob twice per year and pay $150 each time, when that's way above what the landlord's actual cost is, then that's hard-earned after-tax dollars leaving your pocket and going unjustifiably into the landlord's. And whether that's happening because the landlord is super evil or because your landlord just doesn't know and is ignorant, you're still out $300, and that's not fair. And believe me, I tell these young landlords, if you're so lucky that you can own one of these assets, which is out of reach of most people, then it's your obligation to learn all these rules, the things that we go over in this podcast in every episode. And I'm certainly not saying that ignorance of the law is an excuse. No way. What I am saying to you, New York City tenants, is that the ignorant landlord is much more pliable than the evil landlord. And again, evil landlords are few and far between, and you'll know when you're dealing with them because they don't change until you make them. But again, that's not most landlords. So that sets the stage for the takeaways. You lose your key, and the landlord tries to charge you $150 to give you another one. Or your kid is now old enough to come home from school by themselves before you're home and let themselves in, and you need another key for your child. And you ask the landlord, and the landlord says, fine, I'll give you another key, but that'll be $120, something like that. If you're rent stabilized, number one, your kid gets that key for free based on the law that we covered in the second segment. And if you haven't lost your key 3 other times that year, the lost key replacement is also free if you're rent stabilized. So show the landlord the law I'm linking you to in this podcast. And if the landlord refuses to honor that, then you can file with DHCR, the New York State Division of Housing and Community Renewal, the agency that has auspices over rent stabilization. You can file with DHCR reduction of services complaint for an individual apartment. I'll put the link to the DHCR fact sheet on that in the show notes, and I will also put the link to the online application for that in the show notes. Now, if you're not rent stabilized and you don't have that nice proactive option, okay, then you have a couple of options for negotiation, and there's a couple of ways to use the landlord's ignorance against it. So first, you educate the landlord. Send the landlord the link to Real Property Law 235I, and use your own words, but say something to the effect like this. Hey, did it really cost you $150 to make this key for me? I find it really hard to believe that you, as a landlord with a commercial relationship with a locksmith, that your vendor's charging you $150 for this key. In fact, you probably have a key sitting in a lockbox right in your office. I'm happy to comply with the law and pay you your cost, but I'm really not comfortable with turning this into a profit center for you because that's contrary to my rights as a tenant. Then here's where there are two different approaches. One approach is that you could subtly suggest to the landlord that if landlord gets off your back and gives you the key for a couple of bucks, whatever it actually costs the landlord, that this will stay between the two of you. A lot of times this tactic works as a negotiation technique with a misinformed landlord. Let's do some math. Let's say it's an 18-unit building and the landlord gets an average of 1.5 lost key fees per year, and the lost key fee is $150. That's a $4,050 annual upside to the landlord that they will be protecting by not having you blow their cover on this practice. And over 5 years, that's a $20,000 upside. Now, the other approach is for the more social justice minded among us, would be to let everyone in the building know about this illegal practice that the landlord is employing of charging exorbitant amounts for keys that he's not allowed to do pursuant to Real Property Law 235I. So maybe there's a tenant association that would be interested in this information. Now, that may make an enemy of the landlord, or it may get the landlord to a position where the landlord understands that you are not the person to mess with. I don't know. And I'm not telling you which way to go, and I'm not judging depending on which pathway you would take. Everyone has to find their own negotiation style and do what's best for them and their family. I'm just here to give you the correct law and some suggestions for utilizing that law to achieve your goals without a big blow up into a big court case. So, your goal might be to get a new key and not ever think about this again and not spend any money on it, or your goal might be to right this wrong for tenants everywhere. That, my friends, is up to you. And there you have it. So remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.